Hello and welcome to the CLES podcast brought to you by the
Thank you.
Center for Law, Economics and Society, an initiative of the Center for Development Policy and Practice. Before we begin, ma'am, we would just like to introduce what CDPP is. So, the Center for Development Policy and Practice is an independent research institution working on economic and public policy issue with a focus on the development of the marginalized and vulnerable communities. Through the Center for Law, Economics and Society, we aim to examine the evolving landscape or legal landscape in India and the intersections with society, economy, and the governance. I am your host, Momita Burman. I'm a senior research associate here at CDPP. And in today's episode, we will be exploring an important and complex issue, the legal challenges that are faced by the tribal and other vulnerable communities upon environmental laws and how the Indian legal system can balance both the conservation imperatives with the rights and livelihoods of these communities. So it is my pleasure to welcome our guest today, Dr. Sanu Rani Paul. Just a brief about Sanu ma'am is that she is an assistant professor at Symbiosis Law School, Hyderabad, with over 13 years of academic experience in environmental law and jurisprudence. She holds a PhD from the University of Mysore and was also a rank holder in her LLM from Mangalore University. Her research engages deeply with critical questions in environmental jurisprudence, including the right of the nature, ecocentrism, and the legal personality of natural entities. Her work is particularly notable for bridging Western philosophical traditions with Indian non dual philosophies such as Advaita Vedanta, offering alternative ecocentric legal paradigms. She has published extensively in reputed international journals and has received multiple Best Papers awards as well. So congratulations on that, ma'am.
Thanks.
And as
Thank
a
you.
yeah, yeah, and as a scholar and doctoral supervisor, her work continues to shape global conversations on law, ecology, and justice. So thank you so much, ma'am. Once again, is there anything that you would like to add to your introduction?
No, I was just listening to you, and I actually really appreciate the great work that you all of you are doing, especially for the indigenous and the marginalized, yeah, who is not being heard a lot. So that
Mhm.
really deserves a lot of appreciation. Yeah, thank you.
Thank you. Thank you so much, ma'am.
Thanks.
To begin our conversation, ma'am, our first question to you would be, could you just take us through or introduce us to your research journey and share what initially drew you to the intersections of environmental law, ethics, and constitutional questions?
Hmm.
Yeah.
Yeah. I basically I'm a ardent lover of nature. This has prompted to me to ask a lot of questions regarding the current legal regulations and also the pace of the development that is happening today. Without giving any attention to the marginalized, as you say, indigenous communities and also uh, the rights of the nature, because we follow a sustainable development paradigm, and our policies and also our laws are well equipped to look at what we need today. Is it development or the environment? And most of the times environmental protection is only a condition, and also the judiciary or the legislature has got certain things, like you pay the polluter pays principle or precautionary. You take the precautions and go ahead with the development. You pay and then go ahead. So it's very much restricted to certain factors that need to be fulfilled before you start with the environmental, before you start with the development. That actually I noted whenever I was teaching, and then I found certain kind of developments that are happening worldwide, especially by reading a book, Boyd, on rights of nature. And also much earlier to that, I started noticing that okay, sustainable development is not so effective right now, and also there are judgments given by the Tamil Nadu High Court, which talks about sustainable development is something that contributes to a lot of environmental destruction. And what we need today, basically, I observe that it is nothing but rights of nature concept, because we need to talk about the nature rather than talking about us. So if you look at how Article 21 is interpreted, it is interpreted to mean that people have the right to pollution free air and water. uh, Here we are not looking at the needs of the nature as such. So this appears to be really like a illusionary principle, but very difficult for people to think of. But there are already a lot of literature prevailing in this area from the from the West, especially you can see even United States, wherein community ownership is being very much appreciated by the judiciary and also by the legal regulations. And apart from that, you have certain countries like New Zealand, Bolivia, Colombia, and Bolivia. So there are certain Latin American countries, also New Zealand, which actually had taken this concept of rights of nature to the fullest extent. And it also talks for the nature by giving it a legal standing or a legal personality. So this is something that always interested me, and the whole entire concept comes under ecocentrism. That is, yeah. But when I was looking at ecocentrism, I found that it has roots not in the West, but in India. Especially when I was reading the Vedic literature, the Upanishads as well, I could really see that bit in the Advaita Vedanta, which is talking about the new non-dualism. That means me and the nature, there is no difference. The entire, elements of the nature is one. That is actually the concept of Brahman. So I actually my I really work on this area, and then I found that okay, there is an interconnectedness that exists between me and the nature. It is because of nature that I am alive. So rather than actually talking of the West, I started doing a lot of research in the East itself, and that actually is reflected in most of my researches. Also, when I talk of indigenous community, they are part and parcel of the ecosystem. From there, I also looked at the indigenous communities' rights in the New Zealand and Bolivia, Colombia, etc. So I found that all these countries actually take indigenous rights very seriously, at least in paper. In practice, it's a different scenario, but their voices are heard while making an important policy or decision, or when we talk of taking a decision on the development, community participation is much entertained. And also, they have made independent decision making bodies which consist of the state and the indigenous community and also the normal community. So this is what I found. And in India, if you are looking at, you see that indigenous community is not represented well, and we are still giving them the what is it the terminology that they are scheduled tribes and not indigenous. It's a very political and a legal
Yeah.
decision that was taken by the Indian government. Yeah, and also because of that, they are not being represented well, and I don't think that they'll be represented any time in the future as well, because we follow a very top-down approach, and also we are more towards people-oriented approach to right to development. So this concerns us basically. And also it troubles the people who work in this area, because we have seen how the tribals were evicted uh, when the Forest Rights Act was actually enacted, and then again judiciary comes into picture in the in one of the judgments, world first, if I am not wrong, the judgment. So this also concerns a lot of policy decisions, and this is it's an area wherein people need to really work and with work with heart, not with any
Yeah.
calculations.
Yeah.
So yeah, that's what. So
Okay.
yeah,
Yeah, ma'am. I think David Boyd's work, like the book that you mentioned,
rights
it
of
is one
nature.
of the most, yeah, that is one of the most prominent one out
Yeah.
there when it talks about the legal rights of the nature. So, ma'am,
Yes.
my next question to you would be that when we are talking about this, we are building on this. So, in your view, in
Mm,
India, how does these environmental laws and their implementation or the policy
mm,
impact the tribal and vulnerable communities? Like,
mm,
is it different in different parts of the state? Because,
mm,
like you mentioned, the indigenous community in India is so complex and
mm,
there is so much diversity. So, does it
mm.
impact each state differently, and how does it impact them?
So you can see that the vulnerable community, the indigenous community are given a lot of rights under the constitution. So it applies to everyone. There is no differentiation with that. Now coming to applicability to various states. So you can see that previous, like you look at the history of it, like you can see that there was predominantly a Forest Act of 1927. Then Forest Conservation Act came into being, and also under that there is Forest Conservation Rules, right? 2022, which is the latest one, and also you have certain protected areas that are mentioned under different laws. For example, like Environmental Protection Act, it gives also certain cover of protection when it comes to developmental decisions that affects the indigenous communities. But at the same time, you have Wildlife Protection Act and several other legislations wherein the entry of the indigenous community to forest and protected areas like the national park and sanctuaries, etc., are restricted. So the reason is that we follow a system which is given by the Britishers. So Britishers always wanted to have a different approach when it comes to indigenous communities by not calling them as indigenous or forest dwellers or whatever complicated terms that we use right now. So they just mentioned in the Forest Act as villagers, the neighboring the community, village community. So this is very it is very vague, actually vague in nature. And as far as all these laws are concerned, we can see that all these laws applies to the entire territory of India. Except if you're talking about Andaman and Nicobar Islands, they have a different law because their geography is completely different as compared to us. Sentinelese tribe and all, they have a lot of isolation required
Yes.
as
Yeah.
compared to the other tribals of India. So, and also, if you are looking at all these laws and reading them together, you can see that of late, like maybe with the coming of Forest Rights Act, there was actually a difference in approach. Because the Forest Rights Act wanted to give a lot of autonomy to the Gram Sabha. But you can see that it is actually again contradictory with the other laws as well, because of which there is a lot of conflict which is happening. So what we can see is that whatever legislations we have, these are all centrally applicable, and it is applicable to most of the states in an equal footing. So this also creates a lot of issues because the cultural, social, economic backgrounds of different communities, indigenous communities in different states differ. And you look at the South or the Central Asia, or Central India, or the Northeast and all, there, the way of living differ from the state to state. So that also makes the application of these laws very challenging because we cannot have a straitjacket formula for every states, right? So probably the central autonomy is actually making the things a bit complicated. So, yeah, better autonomy to the states and the local government or a community participation can do very well. But you can see with the Amendment of Forest Conservation Rules 2022, the approval of the Gram Sabha is only a part of the process.
Okay.
Unlike the earlier position that existed, wherein you see the Niyamgiri Hills case, the Gram Sabha was made the determinant authority of the rights of the forest community. But now you can see the Forest Conservation 2022 and how it has made the landscape change a lot, favoring the MOEF decisions. So, and now if you want to start a developmental project, you don't have to wait for the Gram Sabha approval. So, with the with the initial level of decision making itself, the project can go ahead. So, this is like undermining the authority of the Gram Sabha. So these are some of the issues when we talk of a centralized governance system,
Governance. Yeah.
which merely looks at the needs and the diversities in the states.
Mhm.
So that's actually a dangerous scenario as far as the rights of the indigenous communities are concerned.
Definitely, ma'am. So, ma'am, when we talk about this tussle between a top-down approach, whereas an ideal bottom-up approach, can you share any examples or experiences that illustrate this tension between conservation objectives and community rights and livelihoods? Like have seen multiple. Like I think
Hmm.
most popular is the Narmada or any other relocation. But is there any example that comes to your mind, especially when it comes to the tribal rights and the
So
conservation?
we can actually look at the Forest Rights Act implementation itself. So there was the Forest Rights Act was enacted, and then soon the people who were dwelling in this forest for many number of years had to actually go ahead and show the proof of their staying in the forest for a quite number of years to the central to the Gram Sabha. So and because of the lack of education among these indigenous communities, several lakhs of the people were not able to show a proof to the Gram Sabha, which actually resulting in their, eviction from the forest. And as a result of which, you can see a lot of hue and cry happening in several parts of India. And also, most of we can see that 50 percentage of the petitions pending for regularization of the forest land rights in the favor of the forest dwellers are still pending before the court. So it's only 50 percentage which is being finalized and been given off to the people, but still 50 percentage is yet to be, clarified by the Gram Sabha, and also it is pending. So here, this is what we can see that, there is a problem in the, in the implementation of the Forest Rights Act, which has been highlighted in a number of judgments. Yeah.
Yeah, ma'am. Now that you're mentioning about the pendency of these cases, how do you see the role of constitutional principles in addressing or mitigating these tensions? Like, is there a way already there in our constitution?
Yeah, actually, you can see that right to livelihood is a fundamental right, you know. But if you are actually reading very anything in particular to indigenous communities, their language, cultural rights, and all protected again under the constitutional provisions. If I'm not wrong, Article 25 of the Constitution. But apart from that, then there are certain areas, demarcated as scheduled areas under the act, under the Constitution, and here and there you can see certain protections, but at the same time what is more important is and a standardization, like what you really want to do, like not in mere paper or in the constitution, but more than that. For example, self determination rights. So do they really have the collective rights that are protected in their favor? And also, where are the explicit cultural, religious rights of them protected? Again, we are going back to the Niyamgiri Hills, wherein the Supreme Court had to actually come and say that, the indigenous community has got the right to worship. But specifically speaking, these are all maybe like inbuilt in the constitution, but at the same time, not always getting an explicit protection under the constitution. So, and also you talk of the specific community practices. How many of us do really know about it? Like their way of life, how many of the people who reside in a state are aware of it? So there is no documentation, and also there is no governmental interference to acknowledge their contribution to the indigenous knowledge system, or or recognizing their cultural practices or religious faith or worship. So because maybe like we are giving them we are considering them a scheduled tribe which requires protection. So that is our way of approach of looking at them. But actually, if you are looking at them as an indigenous tribe or Adivasis, for that term is very important. So we will acknowledge their importance in our lives. So India had a reason not to acknowledge them as indigenous tribes, because unlike any other country, India thinks that every one of us are actually indigenous in India. But if you are actually looking at indigenous tribes and their importance for the preservation, conservation, sustainability of the forest, then obviously they need more explicit rights. rather than confining it to certain particular rights like right to livelihood. Yes, everyone are having right to livelihood, but no one is residing in the forest to have a livelihood. But they are the people who lives in the forest and are dependent upon the livelihood only from the forest. Their way of living is different, but it is not lower than anyone. That is how you can see that New Zealand and all, like, they acknowledge indigenous people's right. They are treated with a lot of respect. So if you look at New Zealand, there is a particular right, a law existing for the protection of their rights over a river, Maori River. So it is
Yes,
because
Maori.
they are considered as, the river is considered as their ancestor. So not only the river, the hill, one of the hills was also considered as an ancestor to them, because because of the reason that they all came before the humans came into existence. A lot of living realities that are associated, and the memories that these entities are having, or because you can see that for the nature we are not required, but nature by itself is an entity. So that consideration none of us are actually having nowadays, because you look at nature as an impediment, and also indigenous community as an impediment. How the Britishers looked at the forest when they came to India, and giving right of even after independence, going ahead with that approach, by allowing the forest for non-forest uses and all. So it is like a disassociation that we can see of disassociation that is actually embedded in most of the Indian laws, uh, by demarcating a clear territory between forest and the people, and also evicting them whenever it is required
Required,
as
yeah.
per a law existing. So
Mm.
where will they go? So what are their rights of self-determination? So that we have to collective, they do have collective rights, but
True.
are we really recognizing it? So this is where they need protection, I believe so.
Protection. Yeah.
Yeah.
So, ma'am, now that you have spoken about, treating nature as an entity, so we can, in one way or another, I think we can assert that the tribal communities in India are sort of the protector or the vanguards
Hmm.
of these, entities.
Yes.
But however, over time, we have seen that they are penalized as well
Yes,
under
exactly.
different acts. So,
Hmm.
ma'am, what exactly is the socioeconomic outcome of such
Hmm.
laws in their lives? Like, how does it affect them that way?
Hmm. So this issue basically comes when you are making a very stricter legal regime that actually demarcates the forest into national park, into a sanctuary, into a reserved forest, a protected forest, without seeing the importance of the indigenous communities. So once it is declared, then they are actually considered as what to say, like encroachers, as ones who actually encroach on the forest. And you can see that 89 of the 106 national parks are established in tribal habitats. So here and here comes the question. Then, what is the status of this indigenous community? So now, and after that, the law is taken into hands, and then they are actually considered as encroachers, and legal actions are initiated. But this is actually not a very good trend. But not only India, approach. So this is not going to help the tribals, or in a balanced conservation. It is not going to have a much help. So we what we need is clear demarcated policies, and also maybe probably some amendments in the existing laws that actually would take into account their rights and others' rights as well. Their rights and the conservation, and also a very balanced conservation strategies, rather than going by a one-sided approach, which is very much people-centric in nature. So we have to actually go for a human-centric approach. So because when you are arresting, also you should see that an indigenous people from indigenous communities lack a lot of privileges that the others enjoy. So are they really being legally represented? So that's actually again the question. And how do they even understand that what they have done is a wrongful thing? So are there being given enough way of communicating? Are they being communicated that they're encroaching into the forest amounted to an offense under the Indian laws? Are they really aware of it? Obviously, I know that ignorance is not a excuse, but at the same time, so even law says that people shall be communicated once a particular area is demarcated as a national park or a sanctuary. It must be communicated to the people concerned. But are you really following it? Are they really aware of all this?
Very
So that puts them under threat. Yeah.
Mhm. Now, my last question was going to be, some recommendations, but I think you have answered it. So, just a follow-up question to that, not just in terms of recommendation, but do you see any best practices other than, New Zealand and Australia that you mentioned from somebody from our neighboring countries, such as South Asian countries, where you think certain legal policy or institutional recommendation can be borrowed from them, and we can maybe look into that?
See, as of now, if you are looking at this, I haven't seen much, but I can say that probably a right-centric approach can be a much better way of balancing the conservation and also taking into account the rights of the indigenous community. So that is very important because indigenous communities also have a human right to development, and also, as I have told you, self-determination rights. They have collective rights. So but disregarding all these rights, going ahead with a developmental strategy is not been a very good practice, as I believe, because considering, as I have told you, the Latin American countries and how they have given importance to the indigenous communities knowledge system and also their beliefs. For example, if you are looking at certain of the Ecuador, if you are looking at, it talks the rights of Mother Earth. So,
Yes.
Mother Earth's right to conserve, and everywhere these rights are recognized because of the activism of the indigenous communities
Mm.
and not because of anybody else's intervention. So here they are silent spectators of all the changes, and there is no voice. So i- that can be changed only with a very massive changes in the legal existing legal regulation. Because after Niyamagiri Hills, Gram Sabha was given a lot of power, authority, or the a collaborative decision making agenda was existing. But now with the current changes in the forest conservation rules, but again the things are back again. The top down approach has been persisting. So these are actually something I believe that a clear cut changes in the existing laws are actually required. And also we need to also be aware of the indigenous communities, because most of the people are not aware of the indigenous communities and the rights that they have. So that is also
True.
very important in speaking for them. So
True,
this
ma'am.
is what
True.
my observation is.
Thank you so much, ma'am.
Sure,
Thank
sure.
you so
Yeah.
much. Thank you
Thank
so
you.
much,
Thank
yeah,
you.
Dr. Paul, for those thoughtful and deeply nuanced insights. This has been honestly one of the most incredible and enriching discussion on a subject that sits at the very intersection of environment and law at the same time. Something that I think over the next not just few years, I think over the decades is going to make a lot of sense to us. So, and again, since it will be uploaded on YouTube, thank you to our listeners for tuning into the CLES podcast. We hope this conversation has offered all of us a valuable perspective on the challenges as well as the possibilities, as Dr. Paul has mentioned, in aligning environmental protection with social justice. Thank you so much, ma'am.
Thank you.